Welcome everyone to Ignite Startup Workshop. Thank you for joining us. My name is Amanda Golden and I am the Assistant Director of the Herb Kelleher Entrepreneurship Center. The Herb Kelleher Entrepreneurship Center in the McCombs School of Business promotes the development of entrepreneurial skills and supports the exploration of the ways these skills can be applied to careers as founders or innovators within established firms. Our Ignite Startup Workshop series provides an opportunity for attendees to learn more about different topics related to new venture creation. These workshops host leaders from various industries and on-campus experts and enable students, faculty, staff, and the greater Austin entrepreneurial community to gain usable skills and insights for launching an idea into a startup or pursuing other career opportunities. Today, we are excited to welcome Karen Landolt to provide an overview of the benefits of ethics in the startup process. Karen Landolt holds a JD and is an assistant professor of instruction in computer science and business, government, and society. She teaches various courses related to intellectual property law, behavioral ethics, entrepreneurship, and service learning. She is involved with the National Association of Colleges and Employers and the First Destination Survey Committee, as well as South by Southwest EDU. Karen, welcome and thank you for joining us on what is a very timely topic in the entrepreneurial community right now, entrepreneurial ethics.
Well, thank you. I'm excited to be here. And this is your workshop. So I do have a prepared presentation, but I'm always happy to answer questions along the way. So there's a Q&A tab in your navigation window. So don't hesitate to type in a question and I will be happy to respond. So today we're going to talk about copyright law and the ethics of giving appropriate attribution to the people who create resources that we might use in our business, and also talk about cultural appropriation within our businesses and ways we might think about these topics. My department at McCombs, Business, Government, and Society, has created an amazing series of free videos called Ethics Unwrapped that anyone in the community can access. But we're going to start with one of these videos that explains the concepts of appropriation and attribution and talks about ways in which we can make ethical decisions about these topics. So let's start with the video.
The thought of people stealing my work, it does bother me and it does upset me, and it almost angers me in a way to know that.
So I just realized that, I guess we don't have the closed caption. I'm sorry, I'll just keep playing.
Someone could get away with that.
As young children, we learned that everyone has the right to control the use of their property.
Hi.
Keep it, share it, give it away. It seemed that simple. But as adults, we find ourselves trying to navigate through physical and virtual worlds where issues of intellectual property and ownership are much more complex. Much of what is ethical and unethical in the area of intellectual property has to do with following the law. While laws governing appropriation and attribution are struggling to keep up and add clarity in our rapidly evolving world, ethical analysis can help guide the way.
I was a camp counselor for a couple of years, and once my kids graduate high school, they are fair game to add me on Facebook. I came across a photo that one of these teenagers had shared on her Facebook page that was a photo I had taken and posted to my Facebook page. And she didn't credit me or link me to the page. I had just come across it. And so I felt violated. If she had credited me for my work and just even tagged me or something, just mentioned my name of who had taken the photo, I really wouldn't have had a problem with it.
Attribution means giving credit where credit is due.
To be or not to be.
In theory, the author of any published work has a right to control how his or her intellectual property is used. But in practice, Most people click agree when signing on to websites such as YouTube without ever being aware that they're signing over the rights to their material to the corporation that owns the site. Sometimes all that's legally and ethically required to use material is a citation explaining its origins. Other times, content is protected by copyright and has explicit limitations. We all know that we're not supposed to plagiarize our papers, but what about artists or musicians who learn their craft by copying famous predecessors?
All right.
Are these original works if they're infused with the style of the masters? Would we call that stealing or influence?
Copying someone's work directly with the intent of using it and passing it as your own, I think is definitely stealing, obviously so.
It's just common to use Shakespeare in like a lot of different new works pieces. And so just giving credit to him obviously is something that everyone would do.
Intention matters, and I would never intend to steal something. I would do everything in my power to actively try not to, but there's a huge difference between influence and stealing.
Music professor and computer scientist David Cope created a computer program that produces original compositions in the style of previous composers. The computer-generated music sounds like Mozart or Bach, for instance, but it's not. 2 CDs have been produced and sold with no legal action taken because the copyrights to the individual works expired long ago. In another case, composer John Oswald created sound collages using samples of previously recorded works. He claimed that the sound collages were original compositions.
Yeah.
He listed all his sources, but did not get permissions to use them. Record companies filed lawsuits, and ultimately, unsold copies of his albums were destroyed.
Yo, yeah.
So, in some cases, the courts have allowed unrestricted use where sampling led to the creation of new pop hits. In other cases of deconstruction and remixing, the courts have decided that these artists must get permission from the copyright owners of the original music.
Even though music and sound are things that can be repurposed, I don't always think that it's necessarily the correct thing to do if you can't talk to someone who knew them and they would be okay with that.
A lot of stuff that's been created, the originals were a lot like back in history, and so anything now is just a copy or a reinvention of that. Nothing. There's very few things that have been original in this time era. So it's a matter of just like, you can't say I was the first to come up with it because there's always someone else who had.
Ethically speaking, using others' intellectual property for one's own gain without permission is stealing. The original creator is denied credit and is deprived of control over his or her creation.
Yes.
Passing off another's property as one's own is an act of deception. But appropriation is more complex. Appropriation can mean borrowing ideas, images, symbols, sounds, and identity from others. Many would argue that progress in art, music, and architecture wouldn't even be possible without incorporating important artistic developments of the past. Sometimes appropriation is ethically permissible, and other times not. For example, many of our government buildings and banks have appropriated ancient Greek architectural features, such as columns and capitals, to project images we associate with democracy, wealth, and freedom. On the other hand, controversial instances of cultural appropriation abound, such as the NFL's use of Native American symbols like the logo for the Washington Redskins.
My friends and I were actually talking recently about Miley Cyrus and how she's kind of shifting from one image to more of an African-American influence. If we asked our African-American friends what they would think about that, what would their reactions be? And that's almost like sampling of an entire culture rather than just like a series of notes or a beat. But that's still, in our opinions, appropriation in some ways because it's not something that's really relevant to what I would think would be relevant to Miley Cyrus.
Whenever possible, we should follow the rules we learned in childhood about respecting the property rights of others. If what you want to use doesn't belong to you, then use it only in ways that the owner permits. If it's impossible to ask for permission, then ask yourself how you would want the creation to be used or attributed if it were your own. And if ownership itself is a subject of debate, then the use should be subjected to a systematic moral analysis to determine what harms the appropriation might cause and whether they are justified. When it comes to appropriation and attribution, the laws may still be murky, but ethical behavior doesn't have to be.
If you come across an artist and you really like how they did a certain skill or a process, it's okay to take that and try to make it your own. And I guess in a more professional setting, you do want to cite that effort that someone else made just to pay respect to that person. That's definitely something that's taught in the art world.
If you're borrowing material from an artist, you definitely need permission for that, just because that artist worked very hard on that, regardless if it's music or art or writing.
It's a good idea to give credit and also put in your own style, because whenever you do create art or something like that, you're taking from another idea that was already there. And you need to be influenced some way or another. So.
All right, so that's a really good overview of our two concepts, right? Attribution, which is just giving credit where credit is due. And all of us are familiar from our time as students that it's important to cite the work of people that if you use their theory or facts, you always want to cite where that information comes from. As the video discussed, appropriation is a little bit more complicated. Sometimes it's considered, imitation is the sincerest form of flattery, and other times it's a violation. And where do you draw that line? How do you decide what is okay and what is not okay? And so I thought I'd start with a case example. So Amanda mentioned I teach intellectual property law, and I practiced this area as an attorney, and my specialty was trademarks. And this is actually a trademark case. So this is a company called Aloha Poke Company. They were founded by a entrepreneur in Chicago, and there was an article written about the choice in name for this company because it went against a cultural understanding of the concept of aloha for Native Hawaiians. And so in July 28th, this was actually a couple years ago. I should have included the year. I just realized I neglected that. I apologize. Anyway, so a Hawaiian activist, and forgive me, I do not know how to pronounce her name, but she made the public aware of a case that was being sent around to any other local company in the United States, in Hawaii, that use the word aloha in connection with making the dish poke. And there are, hundreds of restaurants around the country who make a variation of poke, which is a traditional Hawaiian dish. And there are many, many different ways and combinations that you can combine this. And the activist, Mihau, she represents Hawaii, their Pacific Caucus in the United Nations. And so she's a cultural representative of Native Hawaiians. And she started hearing from a lot of Hawaiian business owners who had received cease and desist letters from this Aloha Poke chain in Chicago, telling them that they could not use the word aloha in connection to poke, because the Chicago company had applied for a federal trademark for this particular brand, Aloha. And so to Native Hawaiians, this concept of aloha is something that no one can own. It has multiple meanings in the Hawaiian language, in the Hawaiian culture. And it's something that was deeply offensive to them, that a business owner would try to claim ownership of this phrase in connection to a native Hawaiian dish, which is poke, and the company originated in Chicago. So they're not even a Hawaiian-based company. And so the question for all of you is, was this an ethical choice by this company? So they legally, the United States has a first to file system when it comes to trademarks, and that's your brand. It's whatever you call your business, like Coca-Cola is a trademark, Mentos for gum is a trademark. And so this company chose to name this national chain that they created selling poke dishes. They chose to adopt a phrase from a language that is not their own, and to stop all other people from using this concept, this term, in connection with a native Hawaiian dish. So they were essentially keeping native Hawaiians from their heritage. So they were legally allowed to do what they did because they were the first company to file for a trademark on the Federal Register. And because it's well, actually, I said first to file. I apologize. That's our patent system. We're a first to use system. And so eventually somebody could have come forward and said, you know, we've been using Aloha in connection with poke much longer than you have. So our rights supersede yours. But for these purposes, they were the first ones to actually file an application in the Federal Trademark Register, which gave them the right to stop others from using the mark. And so in your navigation menu down at the bottom, there is a reactions tab. Actually, I guess there isn't a reactions tab. Never mind. So the question for you to contemplate is, if you were the entrepreneur starting this company, do you think it is an ethical choice to take a name from a language that is not your own, that's connected to a dish that you did not originate, and monetize it, right? And federalize it into a brand, and then stop other people whose culture it represents from using that term. So remember, it was a legal action that they did, but the question is, was it an ethical one? And is that a good choice for an entrepreneur to make when they're trying to sort of win hearts and minds, right? To gain customers for their business. So that's an example of the complications, right, of appropriation. Now let's talk about attribution and copyright law in particular. I'm going to give just a very brief overview of the concept of copyright law. It was part of our founding Constitution. Article 1, Section 8, Clause 8 of the Constitution says that Congress shall have the power to promote the progress of science, that's patent law, and useful arts, which is copyright law, by securing for limited times to authors, copyright law, and inventors, that's patent law, the exclusive right to the respective writings, copyright law, and discoveries, that's inventions, that's patent law. So this idea of ownership and who gets to claim rights to a creation was part of our founding documents for our country. So very important, right, to the concept of a free nation, what we would allow in our business business practices, right? And the actual definition of copyright, according to the statute, is an original work of authorship fixed in a tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, otherwise communicated, either directly or with the aid of a machine or device, right? And so that's a long phrase. There's lots of sort of legalese, and how do we unpack that, right? Fixation in a tangible medium just means that somebody can interact with it in its set form. So we are recording this Zoom cast, and so the recording is fixed in a tangible medium of expression, which means somebody can go back and rewind and watch this presentation, and that's what makes it fixed. You know, a painting of any kind of artwork, a photograph, you know, a toy, anything that is tangible and fixed, and a user can interact with it. That's what it means to be fixed in a tangible medium of expression. Something that isn't fixed is like a live concert, right? If you were to go see Beyonce performing live, it's happening in that moment, and everybody's experiencing it, but they don't allow recordings at live concerts, particularly not Beyonce's, right? Because she owns that. And you cannot rewind and go back and visit a live performance, right? So fixed means that people can interact it in the future from the time that it was set down. So, you know, we're all doing this in the present moment, but, you know, a month from now, a year from now, somebody could access this recording and experience what we're all experiencing together today. That's what makes it fixed. And then there are many different categories of creation that is covered under copyright law. It's a long laundry list, and most of us are pretty familiar with our consumption of pop culture, right? Music, television, podcasts, radio announcements, movies, any of those are all covered. Those creations are covered under copyright law. And so there are these 8 categories, and it's very broad and very comprehensive. And what it gives the creator, right, is the right, and it's a monopoly, which is very unusual in our free capital system, right? Is that we are usually anti monopoly and antitrust, and you know the government regulates these things. But when it comes to intellectual property law, it is an exception, and we do give for limited time, right, exclusive rights to the author and the inventor to exclude anyone else from using your invention, your creation. And so it's a very powerful right that we have under copyright. And also, this is also a little bit talking about patent law. And so anybody who violates that exclusive right, there are penalties associated with it, right? And so then the question that we have when it comes to ethics and when we're starting businesses, where do we draw the line? You know, we always have one area, which is what the law allows, and then there's another area of analysis, which is this an ethical choice for my business? And where is this rooted? And it's in the theory of through Kant, through a natural obligation to respect the author's work. And so that's a deontological approach. And then there's also a utilitarian approach, which is to protect the public good. The video talked about compositions by Mozart and Beethoven. The copyrights have expired on those, right? Because it's a limited monopoly for a limited time. And once the copyright is expired, then it goes into the public domain, and everyone has a right to build upon that previous work, right? And so eventually we have a system that believes that we all benefit from creating upon other people's creations, right? That's how art evolves, is that we combine different forms of expression and sort of put our own spin on it, as some of those students talked about in the video. And so this idea of ethical analysis is you need to ask sort of, is this for the greater good? And is this respecting the rights of the artist? Now, here's an example, right? So famous photograph taken by Art Rogers. The photo on the left in black and white is it's a self-portrait. It's him and I believe his wife. It could be a relative. I can't remember who the other person is in the picture. But they're holding, they've got an armful of puppies, which is just wonderful, right? Who doesn't want an armful of puppies? But then an artist came along who is a sculptor, and he created a 3D version of the photograph into a statue, and he put it in a public park. And he said that he was building on the work of the author, but it was his own creation. But Art Rogers, the photographer, he sued, and he said that's not an homage, that's a copy. You have taken my original work, my photograph, and you have created something called a derivative work, which is you have transformed it into a 3D form. But as the original creator, that is one of my rights under the law. So you have created an unauthorized derivative work of my original photograph, right? And so this was a court case. It went in front of a jury. And the question for all of you is, what do you think? Do you think that Coons has appropriated illegally, unethically, the work of the artist Art Rogers? And so that's a question for you to contemplate. Do you think it is misappropriation, right? That it is unethical to create this statue without the permission or knowledge of the creator of the photograph? And so within copyright law, there's this concept that we have this bundle of sticks, which is this series of rights that we are given that we can take apart and hand to very different people to accomplish derivative works. So, Art Rogers had that bundle of rights, and one aspect he could have chosen was to commission a statue based on his original work. And that is part of his bundle of rights. He could have freely given that stick to Jeff Koons and said, okay, you now have the right to create a statue. But he didn't. He did not give that right. Jeff Koons took that right. And whatever it is that you decided, I will tell you what the court decided. And the court said that Jeff Koons had, in fact, violated Art Rogers' copyright. It was an unauthorized misappropriation of Art Rogers' original photograph. So the court said this is appropriation. It's unethical appropriation, and Jeff Koons has to pay money to Art Rogers for stealing his right to create derivative works. And when we think about derivative works, a really excellent example is the world of Harry Potter. And I know J.K. Rowling is a little bit controversial these days, but we're focusing primarily on her creation, on her original work of authorship, and sort of the universe that has evolved around her creations. And there is a list on the left of all of the different areas that the characters of Harry Potter have been combined with, right? So they have created Harry Potter branded clothing, Harry Potter branded candy, puzzles that depict scenes from either the movie or what was described in the book, various toys, right? And you can see many examples in these photos. And what's important to note is that every single one of those examples is an authorized derivative work of J.K. Rowling's original creation, which is the novels that she created. So this is a very lucrative area of copyright law, which is called licensing, right? And so J.K. Rowling has licensed her right to create these derivative works to other companies that have then created this Harry Potter merchandise for fans to enjoy. And you'll see it's a lot. It's a huge amount of merchandise. And J.K. Rowling has a right to get a percentage of the sales for every single item. The royalties attached to licensable merchandise, it varies within the expression. There's one percentage that is usually given to books, another that's given to posters, right? But it's usually anywhere between 5 and 10% is what the royalties are earned. So every time you buy a Harry Potter wand that was created by a toy company, J.K. Rowling gets 5% or 7% or 10% of the sales. And every single one of them is a derivative work. Now, Congress said it was for a limited time, right? She has a monopoly for a limited time. When copyright was written into the Constitution, a limited time was 14 years. That's how much the founders thought a creator needed to enjoy the fruits of their labor, and then it would turn into the public domain, and everyone could build upon these creations. But the law has evolved and changed quite a bit over the years, and the current formula is life of the author plus 70 years. So I'm not sure exactly how J.K. Rowling is, how old she is, but I'm going to say she's between 40 and 55. She's still, young and vibrant and existing in the world. And so she has exclusive right for the entirety of her life. And then whenever she dies, then whoever she gives her copyright to through her will. It could be her spouse, her child, a foundation, anyone she wants. She can give those rights to them, and then they hold exclusive rights for 70 additional years. So that means that neither you nor I or people we know who are alive today, it is very unlikely that they would have the right to create derivative works of Harry Potter, to be inspired by, to build upon, to play with, without express authorization of J.K. Rowling or her assigns. And so, that raised a question about the ethics of copyright law. Is it ethical for an author to maintain that level of control so that entire generations never have a right to build on that creation? And that's an ethical dilemma that exists in copyright law today. I mean, the law is very clear. People can hold on to it for life of the author plus 70 years. So I am going to list on the screen. I didn't realize that we weren't going to have the ability to sort of vote using the reactions tabs, but I'm going to put on the screen a statement about an action that you or I or people we know probably engage in every day of the week, weekly, monthly, throughout the course of a year. And the question is it an ethical choice that they're making? So the first one is click yes if you have ever made a copy of a CD and give it to a friend. I know that's an old one. Not too many people make CDs anymore, but you may have in the course of your lifetime. And thinking about that behavior, right? Is that an ethical behavior? Another choice is if you ever taken a picture off the internet, used it in a presentation or on social media without the permission of the person who created that image, or even without giving them attribution, right? Without listing the name of the photographer in your presentation. If you've ever edited a clip from a TV show or movie, posted it on YouTube or any other, Facebook Live, TikTok, any other video hosting site, right? Have you ever done this? And is this an ethical action? Another question, if you've used a streaming platform password that is not your own to watch a movie or TV show, right? Maybe your aunt subscribes to Disney Plus and you don't, and you want to watch the new Pixar movie Turning Red or Seeing Red, I can't remember what it was called. And your aunt says, oh, I'll just give you my password to Disney Plus and now you can watch it, right? Is that an ethical action? Is the question. And as an entrepreneur, are you depriving a business of a stream of revenue to which they're entitled, right? These are the questions that that as people who want to start businesses who need to make a profit, do you respect the business models of others and the way in which they have chosen to engage with their customers and earn money? And then the last one, if you've ever walked into a retail store and taken a CD or DVD without paying for it, is this an ethical action? And most of you would say, oh, of course, that's stealing. I would never do that. I would never walk into Target and, take a DVD without paying for it. And the question is why? And sometimes my students say, well, I'm likely to get caught and I don't want to get caught, right? But if I were to download that same movie from a streaming site, if I found some way to break the encryption and download it, well, I'm probably not going to get caught. So then it's probably okay, right? That's sort of the analysis. So with copyright law, every single action that I've listed for you and asked you these questions, every single one of them is actually a violation of copyright law. So you are breaking the law if you engage in this behavior, and you are depriving the creator of their income and their rights under protection of copyright. And so the question is, are those ethical choices? And what's so sort of insidious about copyright is because of technology, we can, copy and paste just about anything. It's very, very easy to take a copy of something and use it and incorporate it into your work. It's almost no effort. And because it's so easy, and because it takes such limited effort, and because it's the owner, the creator of the copyright, it's their job to enforce their rights against any infringer, which means there's no like copyright cops, right? You can't go down to your local police station and say, Professor Landolt played a video that I made from YouTube in her class, and she didn't ask me permission, so I want you to go arrest her, right? Can't do it. That's not how copyright law works. The owner of the copyright has to enforce their own rights against the user, which means they would have to file a lawsuit against an infringer in civil court, and they would have to pay a lawyer to do all of that work. It becomes very expensive very quickly. Now, there are opportunities through some of these streaming sites to report copyright infringement, and then there's takedown provisions where if you tell YouTube, they put up a clip of the movie About Last Night on YouTube, and that I made that movie and they don't have the rights to it, YouTube will take down the clip of the infringer, but the the studio has to monitor YouTube and see if people are abusing their copyrights. So now all of you are probably familiar with this concept of fair use. So there is sort of a get out of jail free provision of copyright law, because it is important for people to be able to benefit from the creations of others, particularly for educational purposes, right? And so not all unauthorized copying is unlawful. So I gave the example of me playing a video in class, me having images, right? These images right here, this came from Twitter. And it does tell you that it came from Trademarks or Magic, but I don't know who that guy is. And I don't know who Timberlake Law is, and I didn't ask them if I could put this photo in my presentation. But what I have is a defense, which is, yes, I have committed copyright infringement. I am guilty. But now I have a defense to my action that because I am using it for one of the exceptions to copyright infringement, which is the idea of an educational use. And that falls under fair use. And I'm not charging you for this presentation. And I am not actually using any of the material that I have presented to you. I'm not using it in the way it was intended. It was intended to entertain. It was intended to inspire. And I am using it to inform. Now, the Ethics Unwrapped video, that was designed for education, and I'm actually using it for its intended purpose. And there is a license on Ethics Unwrapped that says that you can use the videos and you can display them for educational purposes. But the photo of the couple holding the puppies, that was meant for artistic enjoyment. And I used it as an example of a court case, right? So I have transformed the intended use of the original artwork for an educational purpose. So if you're, starting a business and you want to use material that other people have created, the only defenses you have is if you're making fun of what they have created, or if you're using it for educational purposes. But even then, there's a fine line, because the court does look at if money was earned. And so if you take somebody's photo and use it in a textbook and you don't give them attribution, and you don't credit them, and somebody paid for that textbook, then that's not a fair use. You have violated copyright law. Okay, so one sort of last example of the ways in which technology can evolve and can maybe muddy the intent or the impact of the creator. So Netflix is a streaming service I'm sure we're all familiar with, and Netflix has an algorithm that shows its users material based on what the user has seen previously and what the user likes and what they're interested in. And companies, there's a lot of conversation around diversity, equity, and inclusion, and what is appropriate in representation and having diverse images. And so Netflix has an AI, and it turns out that they personalize even the images that you see as an excerpt of a television show or a movie or a stand-up special, right? So if Netflix knows that you've watched a few Uma Thurman movies, and they see you as a fan or interested, when they show you a poster of Pulp Fiction, it will prominently display Uma Thurman in that photo. If you're instead a John Travolta fan, the poster will just feature John Travolta, or he'll be very prominent in that image. But what happens if your interest is in a a minor character in the movie, right? So this woman is a Black woman who is a consumer of popular culture. And she was watching some movies on Netflix, and she noticed something that was very disturbing. Right. So she says, other Black Netflix user, does your queue do this? Does it generate posters with the Black cast members on them to compel you to watch? And so the main stars of the movie are white actors, but in her screen, the images that she saw featured the minor characters who were Black actors as if they were prominently featured in the film. So she gives the example of Love Actually. And so there is an interracial character in the movie. So she sees a poster of an interracial couple. She sees the movie Sierra Burgess is a Loser, and they show her one scene that has a Black actor in it. For the movie Set It Up, she sees there is a main character who is a Black actor, but the poster that she sees for it shows her the interracial couple. And for the show The Good Cop, there is a Black character, and so her images show that Black character, and it tells her, Netflix tells her there's a 97% match. But she asked other users on Twitter to look up the same movies in their Netflix account and to show what they saw. And so similar movies, right? A white Twitter user went to the same movie, and for Set It Up, the poster that she sees is two white actors in the cast. For the movie Sierra Burgess is a Loser, she sees a white actress instead of a Black actor on a track, right? She sees a completely different scene. This is a white man who called up the movie. He sees even a different image of the same movie, Sierra Burgess is a Loser. So he sees a more sort of alluring image of a female, a white female in the cast. The woman sees a sort of fun, friendly image, and the Black Twitter user sees a Black character, right? And the same with Love Actually. Here you see a white couple interacting with one another, whereas the Black Twitter user saw an interracial couple, right? And so the question is that an ethical choice for AI? Are they misrepresenting the material that's available on Netflix? And does that give you pause at all when we think about the concept of appropriation? It's proper attribution, right? It's the name of the company. It's the name of the movie. It gives proper accreditation. It gives proper credit to the creators. But the content is skewed based on the viewer's preference, but it is a misrepresentation because in all of these movies, the Black actors that show up on the on Stacia Brown's feed have very little screen time, and yet Netflix presents it to her as if they are movies that show a Black point of view or a Black protagonist, which arguably they don't. If this is interesting to you at all, if you're curious about copyright law and resources to learn more about it, the UT Libraries has a publicly available links called Using Materials from the Internet. It's also called Copyright Crash Course. And that just gives you a great guidelines to follow if you're starting a business and you're using images on your website and you want to know if it's appropriate or not. So I wanted to leave time at the end for questions. So I've reached the end of my prepared material, and I'm happy to answer any questions that you guys have. So I think you could type into chat or into the Q&A.
And Karen, while our viewers are thinking of some of their questions, I wanted to jump in briefly. And I've learned a lot that I didn't know before. And you have been in a position where you've helped advise numerous students that are looking at, being involved in entrepreneurship and that kind of thing. So what are some of the most common mistakes that you see young entrepreneurs make and when it comes to these topics?
Amanda, that's an excellent question. A lot of people, when it comes to trademark law, the name of your company, which is one of the most important early decisions you can make about your startup, it actually becomes one of the hardest things that you can do is to find a name that no one else is using, that you can actually claim rights to. And a lot of times students misunderstand the role of what the Secretary of State for a state does versus what the federal government does, because you can register your business through the Secretary of State and often as a DBA, doing business as. And so a lot of times students will say, well, I wanted to, name my company, and I just happen to have this on right next to me. And this is Mentos gum, right? And so this is a trademark. It's owned by Mentos, and I want to name my company Mentos Manufacturing, right? So I'm not necessarily making gum, I'm 3D printing images, and I'm calling it Mentos. And I went to the Secretary of State to register my company, and they approved it. So now I have the right to this name, right? Because the Secretary of State approved it. And that is a common mistake that students make, is the Secretary of State is not, it's a rubber stamp entity. They do not analyze whether or not you have the right to use a name. It literally, there's a database, and if it's not exactly, and I mean exactly the same, like you could have Mentos, Inc. versus Mentos, LLC. Those are different. One is Inc., the other one's LLC. And so they tell you you can't have Mentos, Inc., but you can have Mentos, LLC because they're different, right? And so the Secretary of State's office just rubber stamps, you paid your fee, and it's not identical. So we're going to register your business in the state of Texas. But that is not granting you the rights to that name under trademark law. And so the most important thing you can do is a knockout search. When it comes to trademark law, you would do a knockout search through the federal registry and see, if any company is using the term that you want to use for your business. You can also do a quick sort of Google search, and then also domain registry. So I know I didn't talk a lot about trademark law, but that is actually the number one mistake that students make, is they think if the Secretary of State says that they can name their business something, then they have the rights to it, which they don't.
Wow, I had no idea that it was like an exact match kind of. It's like a control F, right? Like just find it, and if it's not an exact match, you're good. And
yeah, because so because they're not they don't make decisions about whether something is lawful. Let's see. Should academic information be open sourced? Where is the line drawn legally when fair use is monetized? Excellent questions, Daling. So open source is a open question, right? Lots of people have different opinions about that. I have not written a textbook, right? So I have no skin in the textbook game, and I know that students don't like paying for content. So I am okay with open source material and assigning open source textbooks because I haven't spent years, months, weeks writing writing something, thinking about how students might benefit from it, and wanting to be compensated for that work, right? And so your opinion about open source, I think, varies upon your perspective. If I'm an academic who's done research and it cost me a lot of money and time and effort and sweat and tears to make it, I want to be able to benefit from my work. But others are like, well, I was paid by my university a salary to create this information, and it's supposed to benefit the common good, so I'm happy to make it public, right? So I think when it comes to open source, I think it's another variable that we can consider, and people who value it use it, and people who think they deserve money for their effort don't. And what is unethical is to make something open source when someone didn't want it to be, right? I know students somehow find ways to make PDFs of textbooks that they spent money on, but then they give their friends a copy of the PDF, and then you're depriving the creator of their revenue. And I would say that is unethical and a legal violation. But if somebody wrote an open source textbook, that's a whole different world, right? Wikipedia, open source, although they are always asking for donations to maintain this open source content. And, you know, I've actually started donating money every month to Wikipedia, because I figure if I take advantage of that resource, I should contribute to the creation and maintenance of that resource. It's not a lot of money. I give $5 a month, but I figured, you know, once every couple of months, I go to Wikipedia and I find something and I use it in my classroom, and they deserve credit for that, right? Now, the line drawn legally when fair use is monetized, that's usually the number one question. The impact of the taking on commerce, right? And so if you make money off of someone else's creation, it's no longer an educational purpose. It's a business, and that is a violation. So it's not fair use if you make money. If you don't have permission, right? If the author says, yeah, I want you to create a video based on my work, and put it on your site because you have 1 million followers, and they're more likely to see it than if I posted it, that's fine. If you have permission and you monetize it, great. It's when you take advantage of someone else's work, you earn ad revenue or any kind of money from the taking, and you do not share it back with the creator. That's where it draws the line. Excellent questions. We have time for one more if people have another question.
Yes, I will ask Karen, you've been so helpful in talking about, you know, some resources throughout the presentation. Are there any other resources that if students are particularly interested in some of these, you know, trademark or those topics that they should access, you know, before moving forward?
Yeah. So actually, I mean, so the government, the federal government regulates both copyright law and trademark law and patent law. And they have websites. So the Library of Congress oversees copyright law, and they have amazing handouts that you can search for. It's actually a pretty good website, and you can search for handouts, or they call them circulars, as well, on certain topics. So if you are curious whether or not something violates copyright law, somebody at the Library of Congress has probably written a circular about it, and you can get that information for free. They're usually between 2 and 4 pages. They're meant to be consumed by non-experts to help give you advice about how to follow the law. So the Library of Congress, excellent resource for copyright law. And then the U.S. Patent and Trademark Office, uspto.gov, has similar educational material around patents and around trademarks. I will say the patent stuff is way denser and harder to understand. Trademark trademark, a little bit less dense. But what is nice is that they're free databases that you can search. So you can at least see if somebody has a patent in a particular invention or a trademark over a particular brand. And that's always a good place to start if you want to know if you might be infringing on someone else's rights.
Well, Karen, this has been super helpful. I've learned a lot, and we appreciate you taking the time out of your day to teach us a little bit on this topic. I encourage everyone to attend our next 2 sessions after this one, Common Ethical Dilemmas Faced by Entrepreneurs, and then Ethics in Action with Robert Prentice and David Quintanilla, also from the Business Government Society Department here in McCombs. You'll find that these are going to build off of one another. And so hopefully, everyone will tune back in for those. And again, thank you very much, Karen, for joining us. And I hope everyone has a great rest of their day.
You're welcome. I was happy to be here, and somebody asked for my contact information. So I'm just typing in my email address at McCombs. That's the best way to reach me. All right. Well, it was a pleasure. Thank you so much.
Thank you. Have a great day.
You too. Bye-bye.
Bye.